we sued on behalf of grassroots partners to extend the voter registration deadline after Hurricane Michael displaced thousands of Floridians. In 2020, we were a little busy in Florida. We first sued the state to ensure that no voter would be forced to choose between their health and voting in the presidential primary elections. Unfortunately, the state refused to implement sufficient safety precautions, and it was later learned that voters in Broward County were exposed to coronavirus at polling locations in the county during early voting and on election day. Last year, we sued again with our grassroots partners to extend the voter registration deadline by 2 days after the state's online voter registration system crashed on the day of the deadline. The Secretary of State's decision to extend the deadline by a mere number of hours no doubt disenfranchised thousands of Floridians seeking to participate in democracy. While the court ultimately ruled against us, this moment that we are in begs the question that Judge Walker had then, when he said, quote, "Every man has stepped foot on the moon launched from the Kennedy Center in Florida. Yet Florida has failed to figure out how to run an election properly, a task simpler than rocket science." So here we are again with Florida. Today we are here to discuss a new lawsuit we filed to block the implementation of Senate Bill 90, a discriminatory voting law passed to make it harder for Black and Brown voters to cast their ballots. SB 90 is an anti-democracy, anti-voter bill that makes it harder to vote by mail, criminalizes line warming activities, and further limits voter assistance at the polls. The new law disproportionately harms Black and Brown voters, violates the free speech rights of those assisting voters, and violates the Voting Rights Act. It would also deny reasonable accommodations to Floridians with disabilities. But with all the harm this new law inflicts, we must put it in proper context. Florida is a state with a long history of discriminating against voters based on race. SB 90 is just the latest effort to silence voters of color who built power in the streets through protest last summer, and then parlayed that power into record turnout at the polls in the 2020 elections, all despite a global health pandemic. In response, the state legislature passed an anti-protest bill and SB 90 in a desperate attempt to maintain power after an incredibly secure election in which many Floridians successfully voted by mail. Thanks to the work of our plaintiffs, legislators cited concerns over waning, quote, voter confidence as the impetus for the new law. But we know this is not true. The Secretary of State publicly stated that there was no evidence justifying security concerns around Florida's 2020 elections. We know the real aim is to silence Black and Brown voters. In fact, you may know that the leading sponsor of the bill, Senator Baxley, said, quote, "Some people ask why, and I say, why not? Let's try it." He wasn't motivated by real concerns around election integrity at all. In fact, he'd rather squash voting rights of citizens than protect our democracy. It also cannot be overlooked that SB 90 attacks the very mechanisms and tools used to turn out and support voters of color during the 2020 elections. For example, for decades, state legislators, especially Republicans, took no issue with vote by mail. In fact, they loved it. Then, when it was primarily utilized by voters of color, that same tool, which was being used to protect the health of those who wanted to vote, it suddenly became suspect, a tool that must be so-called secured with additional barriers. SB 90's measures, which limit vote by mail, curtail access to drop boxes, and criminalize assistance to voters waiting in long lines, lets us know that it is not the specific voting tools legislators take issue with. It is the race of voters now accessing and utilizing these voting options. So we are proud to stand united with our partners, Florida Rising, Faith in Florida, Equal Ground, Unidos US, Poder Latinx, and the Hispanic Federation to thwart the implementation of this racist, anti-democratic, and unjust law. We cannot stand idly by while the state leans into Jim Crow 2.0 and executes a long-term strategy to reduce voter access to the polls, criminalize voter assistance, and silence voters of color in the streets. The groups you will hear from today do work year-round in Florida to clear barriers to the ballot box and assist voters. Our litigation is just one way that we are all pushing back and attempting to ensure all voters of color are able to participate in a free, fair, and just democracy. I will now turn it over to my colleague, Jorge Vasquez, who is the director of our Power and Democracy program at Advancement Project National Office, who will explain the legal complaint and the remedies we are proposing. He'll be followed by the rest of our legal team and representatives from our plaintiffs. Thank you.
Thank you, Judith, and good morning, everyone. It's a pleasure to be here. As Judith mentioned, my name is Jorge Vasquez. I'm the program director at Advancement Project's National Office's Power and Democracy program. We're happy to be here today to discuss our lawsuit. We filed a lawsuit yesterday evening, and within that lawsuit, we make 7 specific claims. It's important to note that out of all these several claims, first, our case asserts that SB 90 is racially discriminatory and violates Section 2 of the Voting Rights Act, as well as the equal protection provisions of the United States Constitution. We know that the methods used by our partner plaintiffs here, specifically the clergy who have been doing sows to the polls since forever, we know that registering voters, providing voters with language assistance has been useful, beneficial, and relied upon for many voters to be able to cast a meaningful ballot. So that's why we also challenge on SB 90 that it violates the First Amendment of the United States Constitution by, protecting free speech. It does so by forcing organizations like our partners and plaintiffs to make statements to potential registrants that they don't believe and will undermine their efforts. Additionally, this SB 90 violates Section 208, which allows voters the right to pick an assister of their choice. When you think about line warming and you think of counties in Florida, many voting sites have parking lots that are less than 150 feet away from the voting door. So in essence, by having 150 feet requirement for individuals to provide assistance, you're essentially denying individuals the opportunity to have an assister of their choice because the people will have to stand far away outside of the polls. We know from this law that it's clear that Governor DeSantis doesn't like Black or brown voters. It's clear that as Florida continues to become diverse, that voters of color are once again under attack. And with this complaint that we filed yesterday evening, we outline particulars around how SB 90 strategically targets Black and brown voters in the categories that I discussed. At this time, I'll bring it up to my colleague, Kira Romero, to discuss the next portion.
Hi, good morning, everyone, and it's a pleasure to be here as well. Thank you all for your interest. My name is Kira Romero-Kraft. I'm the director of the Southeast Region for Latino Justice PRLDEF, the Puerto Rican Legal Defense and Education Fund. And indeed, we are suing the state of Florida for these provisions that are anti-voter. But today, I'd specifically like to talk about how these provisions attack the voting rights of Black and brown communities, and in specifically Latino communities who also are not only discriminated against because of race, but also national origin that is language-based. So at Latino Justice Pro-Deaf, our origins are specifically in voting rights. Since we started in New York in 1972, that has been a focus of the organization that has extended not only to New York, New Jersey, Pennsylvania, Florida, North Carolina, Virginia, as well as other collaborations that we've had throughout the country. In 2018, with some of these same partners, we filed a lawsuit against the state of Florida for failing to provide Spanish language materials to voters who had recently migrated in very large numbers from Puerto Rico to Florida. Even after asking and requesting time with the supervisors of elections to go ahead and ensure that they were providing what is a federal law and is required on behalf of all Puerto Rican voters in the country. Any Puerto Rican voter who is educated in Puerto Rico in Spanish has the right to ask for election officials. Florida still denied the opportunity to even speak on what was required. And so we filed a lawsuit, and just earlier this year, we did enter into a settlement with 31 counties to provide Spanish language materials. And so this law in particular pushes back against communities who have been doing an outstanding job in making sure that every voter exercises their right to vote. And what this does is that it criminalizes activities that our communities have used very successfully to make sure that voters that are impacted are able to vote. What we know is that our community members work longer hours. They have a more difficult time getting to the ballot box. They also have language concerns. In many cases, some of them in certain counties cannot even access information about folks who are running for office, or much less any constitutional changes, amendments that are being proposed, local and municipal issues that are coming up on the ballot. And so this all takes more time, and it takes more education. As we know, democracy is a principle that you fight for. It's not something that is granted in this country. So these line warming restrictions, the 14-day notice that is being applied to our third-party voter registration organizations, our clients in this case, those are all meant to chill the voices of the folks who are wanting to engage and want to register to vote, and who are being educated by the organizations that do the very essential work of making sure that every voter has their voice heard. The restrictions that are applying to vote by mail is something that just a few years ago, the representative in Golia was fighting against, having folks give their identity numbers in a way that could be accessed by a public record request. And yet today we find ourselves with this law that is, again, exposing voters potentially to this practice, which will have their private information out in the general public. And the ballot box restrictions. We have to, again, emphasize the point that last year, Florida was lauded for running an election that, especially given our history, was one of the smoothest that we've ever had. And that was as a direct result of all of the advocacy that the organizations here have done, of all of the very hard work that has been done to push back against the racist laws that Florida has implemented to keep voters of color from the ballot box. We cannot yield any space on this. We cannot accept anything less than 100% of voter turnout, and specifically for voters of color in the state of Florida. And that is why we've brought this lawsuit, and on behalf of Latino, Black, Brown, Asian American, disabled voters, young voters, voters who are in transient status, we are committed to ensure that their votes are counted and that they have access to the ballot box. And now I'd like to introduce co-counsel and our lead attorney on this case from Demos, Stuart Nafee.
Thank you, Kira. And thank you all for joining us today and for your interest in our challenge to Florida's racist SB 90. I'm going to talk a little bit about what we're asking for in this case. Again, my name is Stuart Nafee. I'm senior counsel with Demos. At Demos, we are working to ensure that Black and Brown voters and voters of color and Indigenous voters have access to an economy that works for them and to a democracy that works for them. And the two are, as we see it, inherently linked. You can't have economic policies that benefit the broad American community if you don't have a democratic system that works for people. And in this case, Florida is once again acting to take away voting rights at a time when people of color are having their voices heard in greater numbers. Quite simply, in this case, we are asking the court to stop Florida from implementing the discriminatory practices encompassed in SB 90, practices that are completely unjustified by any legitimate election administration need. None of the election administration professionals in the state thought that any of these restrictions were necessary. In fact, many of the supervisors of elections across the state and across the political spectrum outright opposed many of these changes. We're asking the court to put a stop to unnecessary restrictions on access to vote by mail ballots, on ID requirements that are unnecessary to ensure the security of vote by mail ballots. We're asking the court to halt restrictions on assisting voters waiting in line to vote, many of whom would not be able to stay in line if they were not able to access assistance. And we know that the lines are the worst in communities of color, and these restrictions are a direct attack on those communities to prevent assistance, to reduce turnout, and to prevent the voices of Black and brown voters from being heard. We're asking to halt restrictions on drop boxes, which were used to great effect in 2020 and were able to increase turnout among working people who were able to drop off ballots even after hours. That will no longer be possible. It's also an attack on the Souls to the Polls programs that allow voters to vote on Sundays, even when early voting isn't going on. That will no longer be possible with SB 90. And we're asking the court to halt Florida's compelling organizations like our partners in this case to deliver a message meant to suppress voters, turn them off of voting, and prevent them from registering and participating in our democracy. More importantly, in this case, we're asking the court to put Florida back under federal supervision. Every time Black and Latino voter legislature acted quickly to take back the right to vote from the great majority of those individuals by imposing wealth-based voting requirements on them, requiring them to pay fines and fees even if they can't afford to. Previously, in 2011, in HB 1355, rolled back early voting after Black Floridians turned out in record numbers in 2008, and in particular targeted Sunday voting when Souls to the Polls campaigns in Black churches had successfully turned out Black voters. And these are just two examples in recent years of the attacks on voting by people of color in Florida. And as my colleagues explained, there is no legitimate non-race-based justification for any of these requirements that we're challenging here. There's also no pretending this is really about partisan politics and protecting Republican power in the state. There was no need for this attack on voting rights for partisan reasons. In fact, Donald Trump won the state by nearly 400,000 votes. In fact, SB 90 can only be seen as a direct response to the mobilization and turnout of Black and Latino voters. It is a racist attack on voting. Because of the Florida legislature's unrepentant racist track record, we're asking the court to subject the state to the Voting Rights Act's pre-clearance requirements. That would require changes to voting laws like the restrictions we're challenging here to be cleared by the US Justice Department before they can go into effect. And the state will have to show that its new rules won't diminish the voting opportunities of voters of color, which in this case, we know they can't do because they were unable to point to any legitimate reason for any of these restrictions during the legislative process. Now, as most of you probably already know, in the Shelby County case, the Supreme Court struck down the pre-clearance requirement when it was based on states' historical discrimination in voting. But when a state continues to insist on passing discriminatory voting laws, as Florida has here, the Voting Rights Act allows the court to bring them back under federal supervision. And nothing less than that, Florida has shown, will stop them from continuing to implement racist voting laws and restrict the rights of people of color to have their voices heard in elections in Florida. And with that, I will pass it back to Geraldine.
Thank you so much, Stuart, for talking about the remedies of this case. We now want to turn it over to the plaintiffs, the organizations who are actually doing the work on the ground of engaging, supporting, and mobilizing voters. And so first up, I want to introduce Monet Holder, Senior Director of Advocacy and Programs for Florida Rising. Monet?
Good morning, and thank you, Geraldine. Once again, my name is Monet Holder. I'm the Senior Director of Advocacy and Programs at Florida Rising Together. Florida Rising Together is a 501c3 organization dedicated to advancing economic and racial justice across the state by building power in historically marginalized communities. Our organization develops leaders that will help shift power so communities determine their own destinies. A cornerstone of our work is to expand democracy for a government that works for all of us. Our communities won't be stopped by barriers, voter suppression, or attempts to take away our vote. We educate, register, and mobilize voters as one key way of holding politicians accountable and making our voices heard. In 2020 alone, we made 18 million calls, had over 1 million conversations with voters, sent over 3 million pieces of voter education mail, and registered over 70,000 voters. The actions of the Florida State Legislature and Governor Ron DeSantis constitutes voter suppression intentionally aimed at preventing Black and brown voters from casting a ballot. That is why we are here today as part of this litigation challenging the ban on line warming activities, which will disproportionately harm minority voters who are more likely to have to wait in long line compared to white voters, as well as disabled voters who are less likely able to wait in long lines without assistance compared to able-bodied voters. We are challenging the ejection of nonpartisan election protection workers from no solicitation zone. Florida Rising Together has been one of the leading partners to have election protection advocates at polling locations. We are challenging the curtailment of drop-box access to only early voting hours on designated early voting days, because this will disproportionately harm communities of color. We are challenging the new ID requirements for vote by mail requests and the restrictions SB 90 places on third-party voter registration drives, requiring civic organizations such as Florida Rising Together to tell any voters they seek to register that their registration may not arrive in time to be valid, regardless of the organization's intention or ability to process and return registrations. It is clear that Florida lawmakers and Governor Ron DeSantis do not want people of color to vote. This lawsuit is our effort to prevent them from robbing people of color of the power they exercised in 2020. Using precise restrictions to strike at the way in which voters of color cast their ballots is not about strengthening democracy, it is about restricting it to a few voters. Elected officials should not choose their constituents, and they do not have the authority to deprive people of color of their right to vote. We will fight SB 90 and ensure that all voters, regardless of race, income, or neighborhood, get the access to the ballot that our democracy is designed for. Florida Rising Together will continue to urge our communities to register to vote and exercise their right to vote in upcoming municipal elections and every election moving forward, because our vote is our voice and we must not allow it to be suppressed. Thank you.
Thank you, Monet. I would like to introduce Pastor Stephanie Russell, who is a regional director with Faith in Florida. Pastor Stephanie?
Thank you, Geraldine, and thank you for having me here on today. My name is Stephanie Russell, and I am a community and clergy organizer and director for Faith in Florida. Faith in Florida is a nonpartisan, multicultural, multiracial organization that speaks truth to power. We empower our communities to dismantle and disrupt systems that systematically disrespect and disregards Black and brown rights. We have worked diligently on the ground for the last several years to secure voting rights. We have taught and educated on voter suppression. We seek to expand democracy and to expand the electorate. And we believe that this bill does everything that is against the power and the will and the rights of our community. We believe that SB 90, and which to us is setback 90, is a bill that does nothing less but to be toxic, tainted, and traumatizing to those who have fought for their rights. We have fought through frustration, we have fled and sometimes had to fight, but in regards to all things, we have kept our faith and we believe in the community and our country in which we live. We have fallen from counting jelly beans to be able to vote, to owning land to be able to vote, and now this setback 90, a bill that restricts voters from voting, that restrict those that are on the ground from assisting voters, that dismantle and disrupt the rights of those who we serve. And we want, Faith in Florida wants to send this message and ask this question. Does this toxic bill, how in the world does this toxic bill form a more perfect union? How does it establish justice? How does it ensure domestic tranquility? How does it provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and prosperity? Do ordain or establish the constitutions for the United States of America? How in the world does this bill stand in support that we will secure the rights to vote? Martin Luther King put it this way: injustice anywhere is a threat to justice everywhere. We have sought to engage, encourage, and educate, and we believe that Faith in Florida will remain on the grounds regardless of the obstacles that we face. The Bible says these words: learn to do good, correct oppression, bring justice to the fatherless, and please the widow's cause, according to Isaiah 1:17. We want to be sure to send a clear message to those who have stood against us and continue to stand against us, that Faith in Florida will continue to fight for the rights of their people and to secure that we are able to vote in record numbers. We're determined to make a difference regardless of all of the tactics that stand against us. Once again, we stand against setback bill SB 90. Thank you.
Thank you, Pastor Stephanie. I want to bring up and introduce Jasmine Burney Clark, who is the founder of the Equal Ground Education Fund. Jasmine?
Thank you, Geraldine. My name is Jasmine Burney, founder and consulting director of Equal Ground Education Fund. We are a Black-led community center organization here in Florida. Given the serious threat to progressive values across Florida, Equal Ground is continuing its efforts to engage the rising American electorate, specifically Black voters, through the civic engagement, civic access, and civic representation process with a goal to build and expand current capacity in Black communities. In 2020, we made 500,000 voter contact attempts, trained hundreds of Black leaders, and hosted over 20 Soul Suppose events with Christian clergy alliances across the state of Florida, particularly in small and rural communities. We, along with faith alliances, have found this new law adversely affects the voter participation of those who worship and serve with us. Despite this steady stream of attacks on the right to vote, Floridians of color in Florida was simultaneously known for having built a reliable vote by mail and drop box system. The State Innovation Exchange notes that in 2020, a poll was done that showed 70% of Florida voters support and use drop boxes in Florida, across the nation even. In states that have heavily voted by mail, voters are more likely to use drop boxes than the actual postal service. It is disproportionately impacting voters of color, individuals with disabilities, and anyone who is unable to travel long distances or stand in lines to deliver their ballot during the election period. This law has caused irreparable damage to the minds and hearts of citizens who already feel their vote is suppressed. The constant moving of this goalpost for Black and Brown voters makes a clear case for why this litigation is so purposeful, and we're glad to be a part of the initiative. Thank you.
Thank you so much, Jasmine. I also want to bring to the stage Laudi Campo, who is the Florida State Director for the Hispanic Federation. Thanks so much for being with us, Laudi, and I'll pass it to you.
Thank you. And my name is Laudi. I'm the Deputy Director for the Hispanic Federation here in Florida. In a country where we celebrate democracy, voting should be made accessible for everyone. But instead of making voting easier, HB 90 adds unnecessary hurdles to the process. It reduces the polls in various ways, makes it harder for people to vote, and confuses voters by changing common sense rules that have been increased voter participation. The Hispanic Federation has been working for decades to advance for the Latino community in the United States, and part of that empowerment comes from becoming civically engaged. In Florida, we have been doing this since 2016. Our combined efforts since that time have allowed us to register over 50,000 new voters, engaging more than 1 million voters in the state through phone calls, text messages, and face-to-face interactions. We also created a voter assistance hotline last year, and we received over 25,000 calls only last year. And our media campaign have reached over 3 million Latino voters. All of our interactions with voters have one purpose: to make sure they have the information they need to be able to exercise the right to vote. That is why we're so proud to see how our communities embrace all voting options available for them in the middle of the pandemic and seeing a record turnout. But HB 1990 creates unnecessary burdens for our absentee voting, a voting method that particularly was embraced by our community this year and has helped increase turnout by making it easier for everyone to vote from the safety of their homes. Limiting the times when ballots can be dropped off will seriously impact the ability of members of our communities who cannot vote during business hours, for example, tourism industry. The new law makes it nearly impossible for our staff members to provide language access to voters in the line due to the 150 feet restrictions, and shift the responsibilities to volunteers and staff from the supervisor of election, who in most cases will not be able to provide members of our community with the language assistance they need. We are here today to fight for our rights as voters, for everyone's rights as voters. As mentioned earlier, 2020 was a year that saw a record turnout, especially in communities of color. Voting rights have never been given to minorities. We have to fight for them. We're not asking for special treatment. We ask to keep in place measures that have proven to increase voter participation in our communities. Thank you.
Thank you, Laudi. And our final speaker for our plaintiffs group will be Juliana Dilaro, who is the State Director for Poder Latinx. Thanks so much for being with us, Juliana.
Thank you so much. Again, my name is Juliana Dilaro, and I am the Florida State Director for Poder Latinx. We are a social justice and civic engagement organization that aims to increase representation and participation in the Latinx community and to build a wave where Latinx voters are decision makers of our democracy and play a vital role in the transformation of our country. Our work includes issue-based organizing around immigrant, economic, and climate justice, as well as expanding the electorate and year-round civic engagement. In terms of our civic engagement work, we did voter registration, vote by mail programs, GOTV, and civic education events last year. Last year, through our multi-layered program, we made around 1.5 million phone calls. We sent close to 5 million text messages, and we registered over 40,000 new voters to vote in the state of Florida. SB 90, as everybody has mentioned on the call, specifically harms and targets our communities. People of color, working class people, the Latinx community, we are more likely to work irregular hours. And we really require that 24-hour access to drop off boxes and require assistance with language and in dropping off those ballots. Last year, during the 2020 election cycle, we spoke to dozens, if not hundreds, of voters who rely on vote by mail in such a way that, they needed their family members or their friends to drop off their ballots for many reasons. We spoke to a lot of elderly members of the community who relied on that assistance. We spoke to people with disabilities who relied on that level of assistance. We also spoke to a lot of people who were afraid of leaving their homes, right? Luckily, we seem to be getting to the point in this pandemic where we're getting vaccines and things are getting better. We're starting to see the light, but that was not the case last year. There was a lot of fear in our communities, and that was a rightful fear because Pacific Islanders, Latinos, Indigenous people, Black Americans, they died at a rate double of white Americans, right? So we know what this is. We all know what this is. This is yet another attempt to silence our voices. This has absolutely nothing to do with voter integrity. As was mentioned earlier by Judith, the Secretary of State found there was no election fraud. Vote by mail in Florida went just fine. This is just cowardice. This is not democracy. And that's why we're here, because we are not going to allow them to continue suppressing our voices, right? It's just incredibly sad because this law is so unnecessary and cruel. And, instead of passing laws that make it easier for people to vote, time and time again, we see our elected officials, the GOP, passing laws that make it harder for people to vote, right? And as was mentioned earlier, we know that now for the first time in history, communities of colors are using vote by mail at a similar level than the usual base. They're afraid. And that's what they do when they're afraid of our voices. That's what they do when they're afraid of our power. They pass laws, right? They pass laws like HB1, which basically, criminalizes protesting. They are afraid of our voices. They are afraid of our power. And, we are all here because we care about our communities. We love our communities, and we are not going to allow them to do this. There's a lot of things that we have to do. I think we have to really focus on accountability. So if you're living in an area where your state representative signed on to this bill, hold them accountable, right? Like, vote them out of office. We have to make sure people know that we're here and, we're not going to allow this any longer. So please, speak to your community, speak to your family, make sure that they've been registering to vote way ahead of time. Make sure that they're checking that they're that they're registered, right? That they haven't been purged. Because unfortunately here in Florida, we are in a situation where we have to fight to make sure that we can vote. Thank you.
Thank you, Juliana. And that's a perfect call to action to conclude on. We want to give folks a moment, and we are going to transition into our Q&A session. And we have some questions that are queued up, but we'll give folks a chance to put any questions that they may have in chat. And then we will also make sure that if folks who are on the phone and here through phone, only that they can open up their lines to ask their question. So we are going to kick off with a question from Steve of the South Florida Sun Sentinel. Florida has had a photo ID requirement for more than 2 decades. If a photo ID is required for in-person voting, why should it not also be required of voters who request a mail ballot? So I will kick that over to Stuart from our legal, and then allow Kira or Jorge to jump in on this question.
Thanks, Geraldine, and thanks for your question, Steve. I think I would start by pointing out that there are already a number of protections, of ballot security protections in the vote by mail system. First, a ballot in most cases, is only going to be mailed to the voter at their registered address. And if the voter wants it mailed somewhere else, they have to submit a signed request, which then allows signature verification. There's also verification when the ballot is submitted. So there's a signature there. The voter cannot vote more than once if they've already voted early or something like that. When it comes time to count the mail ballot, the ballot won't be counted. So there are lots of checks built into the system. It's unnecessary to add another one at the time of requesting a ballot. I'd also say that the ID requirement that SB 90 imposes allows only a driver's license or state ID, a Florida driver's license or state ID, or a social security number to be used as ID. It's not the broad set of IDs that can be used when you're voting in person. It's a very narrow set of IDs that will allow you to request a mail ballot. And the other issue with SB 90's requirement is that you have to provide the ID that you gave when you registered to vote, which, particularly for older voters, particularly for new Floridians, may not be they may not remember what it was, and so they'll give the wrong one, and then they won't get their mail ballot. Or it may be that they provided one form of ID when they registered, but now they've got a driver's license if they're a new Floridian, or a student. They've got a Florida driver's license, and so they provide that, but that's not what they had when they registered to vote, and they won't get their mail ballot. So it throws up a hurdle that essentially is, a memory game. You have to pass the memory game. Which ID did you use when you registered to vote in order to get a mail ballot? And it has nothing to do with election integrity. Remembering which ID you had when you registered is not going to increase the integrity of the mail ballot system. And I welcome any of my colleagues to add anything that I missed.
Thanks, Stuart. No, I think you covered everything. There are just two things that I want folks to consider. I think for most of us who have the privilege to be working and have access to these documents, I think it's a little bit out of the ordinary to think, well, I don't have, I wouldn't have a Florida driver license or ID or social security card, but that doesn't encompass all of the electorate, right? That doesn't encompass every single voter in the state of Florida. We have folks that are living in tents, on the roadside. We have folks that are experiencing tremendous hardships, and they shouldn't have their rights to vote taken away because they can't access an ID. That is something that I think fundamentally is wrong with this law and flawed. The other thing is Florida and a lot of other states, unlike some other countries, they don't automatically provide identification to their resident citizens. And that's something that, I can't walk up and say, I lost my Florida ID. I have to pay something in order to get that, right? And some folks cannot afford the $25 that it takes to replace that card when they're having so many difficulties related to the pandemic and beyond in terms of housing, et cetera. So that is something that I would hope that people could understand and put ourselves in the shoes of voters who are experiencing those types of difficulties. And we don't want to dissuade them from being able to exercise their right to vote. And the other important point is, now with this new requirement, for example, let's say that I want my neighbor to pick up a vote by mail ballot and I have to designate them to do so in writing. I'm going to now have to provide my last 4 digits of either social or Florida ID on a form that may be subject to a public records request. That is exposing the private information of Floridian voters for this new law that is an unnecessary change. And I think that that's very important to hammer home because it's not something that we should accept lightly or easily. We have enough issues with privacy concerns, with all of our information being accessible in many different ways. And this is not another way that we need to burden the Florida voter in this unnecessary change to the law.
Thank you. Thanks, Kira and Stuart. We have another question from Jacob from Florida Politics. Does the 2013 decision by the Supreme Court gutting parts of the Voting Rights Act make it more difficult to put the state under federal oversight and pre-clearance requirement? So I will kick that over to the legal team as well to answer that question.
since I was talking about that part of the case earlier, I'm happy to take the first crack at this. Thanks for the question, Jacob. So of course, prior to the Supreme Court's Shelby County decision, 5 counties in Florida were subject to the pre-clearance requirement, which meant, you know, most statewide voting laws also were subject to the pre-clearance requirement. They could go into effect in other parts of the state, but they still had to go through Justice Department pre-clearance. And so there wouldn't have been the need for a lawsuit like this one to prevent these kinds of restrictions from going into effect. The bail-in provision, the so-called bail-in provision of the Voting Rights Act, requires a demonstration that the state has a history of these kinds of racially discriminatory voting laws. And that is what we'll set out to prove in this case. But of course, it would be much easier if the Supreme Court had not gutted the Voting Rights Act, or if Congress would act to restore it.
Thank you. Jorge or Kira, do you, either of you want to jump in or add anything to Stuart's answer?
Yeah, I think the question within itself shows why we need to pass the John Lewis Act, why there is a need for Section 5 pre-clearance requirements, and that in 2021, we still have states that are strategically gutting opportunities to the polls for voters of color. And that should be unacceptable for everyone. That should be unacceptable in every state. And we need to make sure that, notwithstanding the Shelby County decision, that we're asking our federal legislatures to act to make sure that we have pre-clearances requirements, but also nothing would stop us, as Stuart said, from asking for this remedy for the court and having the Department of Justice stepping in.
All right, thank you, Jorge. The next question is from Rick of Florida Politics. Have any other states been placed back into pre-clearance status since the 2013 decision? So I guess this is a question I will open up the floor for folks, if folks know about states that have been placed under pre-clearance.
I don't know the answer to that question. So if anyone else knows for sure, please speak up.
I don't know. That is something that we would need to look up, and we can get back. If we could have the contact information for the reporter who asked that question, we can definitely circle back and respond in writing. Thank you, Geraldine. And thank you. It's an excellent question.
Thanks so much. Our next question comes from Jeffrey, and his question is, what is the main difference between this lawsuit and others that have already been filed challenging SB 90?
One of the main differences from ours and other cases is that ours is the only case that explicitly alleges race discrimination. Also, our plaintiffs are unique. They represent the entire state of Florida and Florida's diversity. We have clergy, we have organizers, we also have Florida are Latino. This is the only case that involves the Latino community as well as other communities of color.
All right, so that is the end of the questions that we have in the chat. We want to open it up in our remaining 5 minutes for folks who have connected via phone. If you would like to unmute, we just ask that you give us your name and your outlet before you ask your question. So we'll give folks just a moment if there are any additional questions. All right, I would just end with this, and I would kick a question over to our plaintiff group. As we come to the conclusion of this press conference, is there anything else that you would like to say about the lawsuit or your work, or you feel like you did not have the opportunity to say that you would like to say in this moment? And I will kick that to our plaintiff group. Any other thing that you would like members of the media to know that you feel are important? All right, well, seeing none, I want to thank everyone for joining.
I'm sorry, I was just a little bit delayed. But
Go ahead.
I want to say on behalf of Faith in Florida, our executive director, Rhonda Thomas, and those that are laboring on the ground, that we're not fighting this fight just for us, but we're fighting this fight because we have eyes that looks up to us. We have children riding in the back seat that looks in the mirror as we look in our rearview mirror, and we see their eyes looking upon us. They're counting on us. So we're standing because our children need a right to vote. Our grandchildren need a right to vote. We stood on the shoulders of our ancestors, and now our children must be able to stand on our shoulders. And so we're in this fight because we believe in the rights of all people. Thank you.
Thank you, Pastor Stephanie. I'll just pause one moment. I don't want to preemptively cut folks off, but if anyone else would like to make some concluding remarks. All right, hearing none, we're going to bring this press conference to a close. And we want to let folks know we have recorded this. Just once again, we will be sending this out as a follow-up to everyone who attended the press conference. So if you have colleagues who were unable to attend, if you have not received our press release, we will make sure that everyone who has also attended has received a copy of that press release. And folks who are on this line, both our plaintiffs and partners, as well as the legal team, will be available for any follow-up interviews or questions you may have. And so you can email me directly at jk@advancementproject.org. I will put it in the chat. And you can email me to get in contact with any of the folks you've heard on this call. So thank you so much for joining us. We thank you and we appreciate your time. Have a great day.